The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to this Friday session of the Kansas Supreme Court docket. I welcome counsel as well as those who are watching us through our Supreme Court live channel. With that, I would ask Mr. Doug Shima, the clerk of the appellate court, to please call the 9 a.m. docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Friday, December 18th, 2020 consists of one case. Appeal number 115184, Ziad Khalil Alsalaami versus the State of Kansas, Riley County, briefs both sides. The appellee, State of Kansas, has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, the state appears by Deputy Solicitor General Chris Elslager.
May it please the court, Richard Ney appearing for the appellant, Ziad Khalil Alsalaami.
Mr. Elslager, you may proceed with your argument.
Thank you, Your Honor. I'll start with a brief summary of the factual history of the case, the procedural history, how we got here. The defendant in this case, Mr. Khalil Alsalaami, is an Iraqi national that was employed by the U.S. Army as an Arabic English interpreter for roughly 5 years in Iraq before coming to the United States, where he settled in Manhattan and worked at Fort Riley as a training U.S. troops. In 2011, he was convicted in Riley County District Court of 2 counts of criminal sodomy for sexual conduct he had with a 13-year-old. He directly appealed and his convictions were affirmed on appeal. And then he subsequently challenged his convictions through a KSA 60-1507 motion alleging ineffective assistance of counsel. The district court rejected his claims of ineffective assistance and denied relief. He appealed to the Court of Appeals, and the Court of Appeals reversed the district court, finding several instances of ineffective assistance, but primarily ruling that his counsel was ineffective for failing to obtain an Arab-English translator for him at trial. This court granted the state's petition for review. It affirmed the Court of Appeals, but on a different grounds. Rather than ruling on the interpreter issue, this court found that his counsel was ineffective for failing to file a motion to suppress the statements he made to police. 2 justices dissented from that decision. The state filed a motion for rehearing, and this court granted the state's motion for rehearing, which brings us to where we are today. It is my intent to initially to address the court's majority opinion, since we're here on rehearing and where the state believes the court erred, and then time permitting to go ahead and address the other issues that were raised on appeal, and of course answer any questions as necessary to the court. Obviously, the state believes the court was wrong to dismiss counsel's strategy as unsound. Counsel adopted a strategy to attack the confession as a false confession rather than as an involuntary or coerced confession. So he made a strategic decision not to file a motion to suppress, mostly because both counsel didn't think it had any merit and thought it would waste their time and cost them credibility with the judge. And it's well known under Strickland that strategic choices that are made after a thorough investigation are virtually unchallengeable. And it doesn't matter whether a different attorney would have done things differently, or even if the best attorney would have done things differently. That's not the standard. And the court, I know, is aware of that. And it also doesn't matter that the strategy didn't work. Let's be honest, in most criminal cases, the criminal defense strategy doesn't work, or at least in the cases that get to the appellate level, the strategy didn't work, but that doesn't mean that counsel was ineffective for choosing that strategy. It doesn't have to be a good strategy. To quote the 10th Circuit, for it to be ineffective, it must have been completely unreasonable, not merely wrong. And that's from Boyd v. Ward, that's cited in our briefs. And again, the 10th Circuit has noted that only on rare occasions can a court conclude that counsel's informed strategic decisions are unreasonable. And in those cases, how the 10th Circuit framed it is counsel's decision must have been so patently unreasonable that no competent attorney would have made it. And I don't think you can say that here. I think they had a strategy. They investigated the possibility of filing a motion to suppress, considered all of the factors, and both counsel, in discussion with Mr. Alsalaami, determined that it just wasn't worth it. It wasn't going to work. Such a motion was not going to be meritorious, and they should spend their time and efforts on other things and not risk losing any credibility with the judge by filing motions that they knew they were going to lose.
Counsel?
Yes.
So you have two grounds for reconsideration, and you've discussed strategy. It seems to me that the strategy not to file a motion really depends on its merit, which is really your first basis for requesting rehearing. Would you agree with that if it was not a meritorious motion, the strategy makes sense, but if it was meritorious, strategy doesn't insulate that decision?
Well, I would mostly agree with you, although I would say that even if it was possibly meritorious, that doesn't make the strategy unsound. It just has to be a reasonable decision, because honestly, reasonable people, lawyers, they do make wrong decisions. That doesn't make it unreasonable. But I would say that a lot hinges on just how meritorious it was. And if you look at what counsel in his investigation, what he considered, he considered whether Mr. Alsalaami was even in custody, and that's a very arguable point, as the dissent in the original opinion pointed out. He wasn't in custody initially. If you look at the facts, he was asked to come to the police station. He was not under arrest. He was not confined. He was not told he was not free to leave. It wasn't until he actually confessed to having sex with the girl at that point that the police said he was not free to leave and he was under arrest. So up to that point, there is nothing that could be suppressed. So his confession at that point would be admissible. Statements beyond that, what counsel looked at, and what I think this court should look at, is he was given his Miranda warnings. They weren't the rote standard Miranda warnings that police read. The police officer actually took more time to further explain the warnings, make sure that Mr. Alsalaami understood them, make sure that he wanted to speak with them, and that he was okay with that. Other factors, of course, the language issue factors into this, but as the police, the district court, and counsel all concluded that Mr. Alsalaami had a sufficient command of the English language to understand what was going on in that interview, and to answer questions and to waive his rights and so on. I mean, he worked as an English translator for 5 years, so he understood English.
Counsel?
Yes.
Counsel, is it your position then that a false confession is mutually exclusive to a tricked confession?
No, actually, in this case, the counsel's strategy, what his argument was that he was tricked into making a false confession. He wasn't coerced into making a confession. He wasn't forced into it. He wasn't threatened. He wasn't involuntarily, tortured into making a confession, but he was tricked into making a false confession. I mean, he voluntarily made it, but it wasn't accurate. And,
being voluntary presumes that it's knowing and voluntary, right?
Yes, in making the statement. However, the idea of false confessions is something that comes up a lot in the criminal justice field, and people will tell you that innocent people make false confessions for a variety of reasons. That doesn't mean they're involuntary, but they confess to something they didn't do, either because they believe that's just what they need to do to get out of the situation. They are tricked, which was what defense strategy was in this case. Here the defense strategy was that, look, they minimized this to the point where they just got it, convinced him that all I had to say was, yeah, it was consensual and the whole thing would be over. And so they tricked him into confessing to something that he didn't do, as in he made a false confession, a confession that was not true, but it wasn't coerced. It wasn't involuntary. There was nothing that would get it suppressed because he was not in custody. once he was in custody, he had been read his Miranda rights and been fully informed of his rights, and he waived those rights. He understood the language. There was nothing in the interview that led counsel to believe that it would be that there was any chance of success on the merits, that it would be suppressed. And
Counsel, I have a question. So just taking a broader view, and I wasn't on the court for the other case, but it seems like in your motion to reconsider, what you're advocating for is for us to adopt the federal Kimmelman standard, which to prevail on an ineffective assistance of counsel claim, in this case on a motion to suppress, that you must show it's meritorious. So is that what you're overall advocating for, is for us to make the standard similar to or identical to what seems to be adopted by most federal circuits, that you must show it's meritorious as part of the ineffective assistance of counsel?
Absolutely. The ineffective assistance of counsel claim is a federal constitutional claim. So the standard employed should be the same as the federal standard. And the federal courts have made it clear that it's not just enough to say, well, he could have filed a motion to suppress. It might have worked. He has to show that it would have worked. And not only would it have.
If we're convinced by that, then we have another legal question that's posed. And I read 10 cases probably, and it seems to kind of be all over the place. Would you say that question, whether it's meritorious, does that go under the deficient performance prong, or does that go under the prejudice prong?
That's a good question, and it could be both, because the courts have said, look, counsel he can't have performed.
For us to clarify. So if we're going to clarify, what is your position on whether that should be part of the deficient performance prong or the prejudice prong?
Well, I think the starting point is a deficient performance, and counsel cannot be deficient for failing to file a motion that would fail. However, if you decide that, well, there might be some possibility that this had a shot, then I think you go to where you think any reasonable counsel would have filed this motion. I think you still then need to look, then ultimately, would it have succeeded? And so then I think you would address it the same way you would address a motion to suppress on appeal. You look at all the factors and say, well, like in this case, I don't think there's any chance that it would have succeeded. But then there's also a next step. Just the fact that it would have succeeded doesn't establish prejudice. Then you have to look at, had it succeeded and had that evidence not been admitted, would the outcome of the trial been different? And I think here you can't say that, because this confession was not the only evidence. I mean, one, you had the victim testified.
Right. You're almost out of time, and I just have one other question, and it has to do with the interpreter issue. The statute 75-4351 seems to be very clear. And when we read the plain language of the statute, it says, shall be appointed when the primary language is other than English. How do we deal with that plain language of that statute?
Well, there's a variety of aspects to the statute. Number one, that shall language, whether it's mandatory or permissive, is an open question. The court's never fully addressed that. And there are many instances where the court has reviewed statutes with the word shall and determined it to be permissive under the certain context. I mean, I've had a case where I won on that particular issue. I would also point out that the statute is directory towards the courts. It provides, I think in State v. Zuniga, Zunga, the court said it provides the authority for the government to appoint an interpreter. But I would say it's not directory on counsel. There's nothing in there that says counsel shall ask for an interpreter. There's nothing that says the defendant shall ask for an interpreter if he doesn't want one. It is directory on the court. I would also point out that in Zunga, the court said that there's no sanction built into the statute for failure to follow it. So it's not a basis for suppressing a statement. So I would submit to you that the statute does not put any kind of a commanding burden on defense counsel to demand an interpreter. And that's what we're here on is ineffective assistance of counsel. So was it ineffective for counsel to not demand us an interpreter under the statute? Knowing he could get one, he didn't feel one was needed. And there's nothing in the statute that says counsel has to ask for one. I think you could read the statute to say, well, if the defendant and counsel ask for an interpreter, the court then shall appoint one. And that's a different question, and we could talk about that. But it's not, it doesn't put any burden on defense counsel to demand an interpreter. And also, I believe the Zunga case had to do with the police interrogation. And there, the court said that failure to follow the statute doesn't provide a basis for suppressing the statement. You still have to look at all of the traditional factors that go into it.
Counsel, you may not, I'm a little bit in the weeds on this question, but I'm having trouble with my computer. So let me see if you remember this. Did in the 1507 motion, did the district court make a finding about whether the defendant was in custody, or was it just a reference that there was an issue to it? I know what I said in the dissent, but I have a note about it, but I can't find it here. And I just wondered if you remembered.
No, I believe that when it came to that point, the court said it adopted the findings of fact and conclusions of law that were in the state's answer to the 1507 motion, I believe. And I feel very certain that in the state's response to the 1507 motion, the state asserted that he was not in custody. I will, I don't have it at my fingertips right now. That's my recollection. Perhaps in the interim when opposing counsels are, I'll see if I can find that. But I believe that is the case. The court adopted the state's findings of fact and conclusions of law.
No, you're right.
That's my recollection, at least.
Yeah, you're right about that. And that refreshes my memory, but it's frustrating when the machines don't work here. So I'm sorry.
Other questions? Go ahead.
Thank you, Chief. On the interpreter question at trial, at the 1507 hearing, I think it's uncontroverted that at least some of the proceedings were not understood by the defendant in this case. And I believe his trial counsel even testified that, legal terms, portions of closing argument, and the defendant himself testified that that percentage was 80%. Now, I think that might be controverted, but what is enough to implicate his constitutional right to be present?
Well, yes, there was agreement that there were some words, some phrases that perhaps he didn't understand, some that he had to ask for clarification. But I would submit to you, just as they did below, that some of the stuff is, in any court hearing for even a native English speaker, there will be potentially some terms, some events that are not clearly understood. It depends on, I guess, whether they're material. Like they brought up like the DNA evidence, like what's an allele? I don't know. I don't even know if I'm saying that right. I know it's part of the DNA evidence. I understand how the DNA evidence, how they make identifications. And if you look at, even at the interview he had with the police, Mr. Alsalaami understood what DNA evidence is and that it's used to make identifications. Was it critical that he understood all the scientific evidence? No, I don't think, because I don't think even a native English speaker would understand all of that terminology. To the extent where there were points where he maybe didn't understand something, I believe that he asked for clarification. He had Mr. I believe it was Platt, the other attorney, was at the table with him to answer questions. After each day of trial, they said they went and back to the jail and they talked with Mr. Alsalaami to ask him, discuss the events, ask him if he had any questions, and they said that at no point in time did he ever say that he didn't understand what was going on. Did he ever express confusion? Anything like that. I think you have to look at the totality of it, and there's just no indication that he didn't know what was going on, didn't understand what was going on. This is not like the Calderon case where that individual did not speak English. Here, there could be no dispute. Mr. Alsalaami speaks English. He worked as an English interpreter for 5 years. He lived in the United States for a year and a half, again, working at Fort Riley, interacting in English. He spoke with the police in English. He understood English. Now, to the extent that there might be some individual pieces where he didn't understand, I think the burden would be on him to show, where that is, so that he could show counsel was ineffective. So, I mean, after all, this is his burden. It's also his burden to show prejudice. So he would have to identify those points in the trial where maybe he didn't know what was going on and show prejudice. But he didn't argue prejudice below. I think actually he's waived prejudice argument. He argued, well, it's structural error. If I show ineffective assistance, I win. So he kind of waived the opportunity to show points in the trial where he was prejudiced by his purported language barrier. Although, as I submit, as the district court found, there really wasn't a language barrier. Did that sufficiently answer your question? Are there any other questions from the court? Then, Mr. Chief Justice, I would reserve the rest of my time.
Thank you. Mr. Nay?
It please the court. First, if I do nothing else, I need to again correct the petition for review filed by the state, where the state argued that Judge Bosch, the 1507 judge, was in the best position to determine Mr. Alsalaami's ability in English. That is not true, because at the 1507, the only contact Judge Bosch had with Ziad, we had an Arabic interpreter for the entire hearing. So that is just an argument of the state that is not based on facts at all. Secondly, I would hope that we can agree that there are some things that are fundamental to due process. And one is the right for a defendant to understand what is going on in his or her trial. I can't get my head around the fact that it's okay that a defendant, because their language barrier, just doesn't get some of it. The state has said that the Court of Appeals was wrong, that in Justice Arnold Berger's opinion, she was reweighing the evidence. She was not. And I want to make that absolutely clear. What she said is, as previously discussed, the district court found that Ziad was able to understand what was happening at his trial and effectively participate in his own defense, a finding that is not supported by competent evidence. And she goes on to state that if you look at the testimony of the attorneys, Clark and Platt, they do not support that. I asked Mr. Clark numerous questions about what Ziad would have understood. I went over some of the DNA evidence, and I asked him about specific words like fragments, profiles, elimination. Those are not scientifically technical words, but they relate to the DNA. And he said, I would expect that the words you reference, he probably would not understand. I asked him about the closing argument, and I could have gone on and on and on throughout the trial. I said that the state argued the word knowingly, voluntarily, compulsion, and used the phrase unconstrained by inference. And I asked if Ziad would have understood that. He said, probably not. In conclusion, I said, so you knew he did not understand and would not understand at least a percentage of what was going on at trial, didn't you? Yes, was his answer. What percentage was your thought? Answer, I don't have a thought on that, or didn't have a thought on that. Well, so we know every witness who testified says Ziad did not understand what was going on. Platt and Clark testified to that. Dr. Cabral, our language expert, who literally wrote the book on English as a second language in teaching environments, said he would have understood at most 50%, that his English comprehension was that of about a 5-year or 6-year-old.
Counsel,
Yes.
is there any evidence that the defendant knew he had the right to request an interpreter?
No, there was evidence that he did not know. I asked Mr. Clark, and let me see if I can find that, if he knew, if he had told Ziad, and this is on page 13 of volume 10, the 1507. My question, did you explain to your client this statute, that the statute required that he have an interpreter? Answer, no, sir. And the Court of Appeals went into that it was never explained to him, that he never waived.
Mr. Ney, is it,
Yes.
I just read right before we came on, I read the 1507 transcript, and it appears that he testified, your client testified that it was kind of a strategic decision not to have an interpreter because they felt like somebody who interpreted for the Army, why would they need to have an interpreter? So there was some evidence presented at the hearing about that from your own client, correct?
Yeah, but my client said he asked for an interpreter and was advised not to have one.
Right.
But here's the problem with that. It's a stupid strategic reason, because Mr. Clark was arguing, oh, Ziad didn't understand what was going on in the interrogation. Therefore, he was tricked into making these statements. I'm at a loss how not having, if you had an interpreter there, where showing to the jury he does not speak English very well, to show how that he wouldn't have the ability to go toe-to-toe with the police. So, and then we had Professor Camus, who's a mathematics professor from K-State, testify. He was the interpreter for the first part of the case when prior counsel was on. And Professor Camus, being a mathematics professor, rated his ability in English at a 0.01 out of a scale of 10. The court gives one sentence, the district court, one sentence to Dr. Camus's that he testified to that, and two sentences in its 50-page opinion to Dr. Cabral. And says that the finding by the district court was that, well, the lawyer said it was fine. Well, the lawyers didn't say it was fine. They gave their opinions, it didn't matter, but they didn't say it was fine. And the judge below never, ever addressed the conflicting testimony of the lawyers saying there were good parts of this he didn't understand. So you have Platt saying there's a percentage he didn't understand. I don't know what it is. Dr. Cabral, the language expert, said at least 50% he wouldn't have understood. And my client saying about 80% he didn't understand. That's significant.
But
Let me, the court's order at page 9 is where he gets into whether the defendant understood what was going on at trial and elsewhere. My question has broader application, but it has specific application here. We ask this question to ourselves all the time when we have a videotape. And so we have the recorded interview of the defendant with the police. And the trial court says that it reviewed that recorded interview and had an excellent, and that found that your client had an excellent understanding of English on all subjects, and very clearly described the sex acts he participated in. But here's my question. When you're sitting where we are as an appellate court that's supposed to not reweigh the evidence, but we have a videotape, how do we use that videotape in our analysis as to whether the trial court had substantial competent evidence for its proceeding? Because it almost feels like we have to reweigh facts or find new facts out of evidence when we're looking at a tape. Does that make sense?
Your question makes sense. I'm not sure I have a great answer for you, Your Honor. But my point would be, if you look at the Stone case from this court, which talks about how evidence should be looked at in circumstances like this. This court has said, quoting from Stone, it's a dual standard of review to look at a judge's decision. In this case, substantial competent evidence does underlie most of the factual findings, although the trial judge ignored the more egregious statements made by detective during the interrogation. Second, we reviewed de novo the ultimate legal conclusion made by the trial judge. It is on this point that we believe the trial court erred as a matter of law in failing to look at the circumstances of the interrogation in totality. So I think this court can look at it, but has to look at it in the context that the district court didn't. And let me explain that. Dr. Cabral, I asked her, and this is at page 190, 91, whether this statement that was given to the police, the interrogation, whether Ziad was holding his own. And here's what she said. I said, do you believe that he was holding on? She says, no, I don't. He actually had few opportunities to respond, or there were few indicators that he responded with other than one word, yes or no, or short, and where he tried to put something more together or to present an alternative scenario, it fell apart. So you at least have to tip your hat and give credence to the language expert and not just the court say, well, I looked at it, looked good to me. So I think if the court does look at it, you'll see him stumbling around. And we do know, do we not, that non-English speakers, sometimes yes, 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 when they don't know what they're replying to. And if you look at Ziad's testimony at trial, take a look at that. I mean, he is stumbling around. He is saying he doesn't understand words that the attorneys are asking. He said, what mean occurred? Meaning, what does the word occurred mean? What mean? He doesn't know the word compel. And even Mr. Clark testifies that during this period, he's having a hard time understanding it. He admits that they were talking about $35. The court reporter had it, but he had to ask him twice what he was saying. So, I mean, he's having difficulties. The prosecutor argued here that, well, there was another attorney there sitting with him to help him. And I think that's an indication of how bad this situation was. Because when I talked to Mr. Platt at the 1507, when I questioned him, I asked him, okay, so you're talking to him. Why? What are you doing? He says, well, I'm dumbing things down. Dumbing things down. Well, that's an indication not that he's helping him, but that he needs help other than Mr. Platt. Look, if I'm an English-speaking attorney and I'm sitting next to someone who doesn't, has severe questions about English, how do me repeating it help him? And then I asked Platt, I think the critical point, so while you're doing this, while you're whispering in his ear, trying to explain things to him, what's going on? Platt says, what do you mean what's going on? I said, what's going on in court? Because I said, I've read this transcript. I never see a point where you say, time out. I need to talk to my client. He says, well, I didn't do that. So I said, court is going on and on and on. And so he's missing, while you're talking to him, he's missing what's being said. And Platt said, yeah, that's true. So his explaining it to him, taking time to do that, is taking Ziad's attention away from what is being said. The court below never talked about Captain Nussbaum, his commander in Iraq, who said he has the ability of about a kindergartner. He just find his name in the court's opinion. I don't see it. Or the driver's license examiner that we called. Why would Ziad go to the driver's license and have to bring someone with him to help him take a test, take the picture test, if his English is so great? He can't even pass a driver's license exam. The state argues, and if we get to the motion to suppress too, by the way, Dr. Cabral testified about that. And she went over Ziad's ability to understand Miranda. And she said when she talked about the word a point, he thought it meant point. He didn't know the word while. You have an attorney present with you while being questioned. He didn't understand that word at all. And this is years later. And she said, in fact, that he was doing his very best because sometimes he'd go back and try and correct things. As to the statute, which,
Mr. Nate, can I just interrupt really quick while we're on this? I reviewed again, I only reviewed his testimony at the 1507 hearing, but I didn't find anywhere where he actually said that his confession was not voluntary. I mean, he talked about being tricked and he talked about not understanding, but he never said, you know, look, I was coerced, or or it was involuntary, or.
well, and I'm not sure he would have understood that concept. I'm not sure that's something for him to understand. I think if he was tricked, if his language incapacity was used against him, that's an issue. And this is also a Miranda issue, not just a voluntariness issue, because if he didn't understand Miranda, he didn't understand Miranda. And we even went into the issue that how the police operate in Iraq might be very different than they operate in the US. So his experience with police would have perhaps tainted his understanding of what he was allowed to do or not do. And that should have been presented. And let's remember, it's not that they didn't file the motion. The motion had been filed by previous counsel and they withdrew it, which this court in its original opinion in this case said was an illogical strategy. That's how this court put it, as agreeing with the Court of Appeals. Let me make one more point. I see my time is up, but if I may.
You may.
Thank you, Your Honor. The state is saying shall doesn't mean shall. Well, let's look what the reviser of statute says. In chapter 6, the reviser of statute says, well, we're changing some words. And the reviser of statute says, generally, Kansas statutes and case law use the word shall to mean must, and may to mean should or may. Well, that's what the reviser of statute is saying. And then you pull a statute at random, and I pulled the election statutes just because I've been looking at those lately for whatever reason. And they say, talking about poll watchers, shall be so appointed in writing. Appointment shall be filed with the county election office. Does that mean may? You don't have to be appointed in writing. Every word in this statute is shall. So if we're going to say shall means may, then we're really turning a lot of laws on their head. And I think the statute is clear. Calderon is clear. Your Honors,
What do you make of the state's argument that the shall is for the district court, not for council? You know, and council, once council makes a request, then the district court shall.
All right. 2 points to that. One, we also raise ineffectiveness on appeal. And Mr. Clark was the lawyer on appeal. He did not raise the language issue, he did not raise the Calderon issue, which he could have. And the point being is that when you look at shall, he could have raised it on appeal and he was found ineffective on appeal. So shall would apply to that, to the district court. Secondly, if you're telling your client something contrary to the law, oh yeah, you don't need an interpreter. And Clark admitted, as I read from the transcript, I did not tell him the statute said he shall have one. So that shall makes a big difference here. And I think it goes to the issue of the strategy, if you will, which this court found illogical, as did the Court of Appeals in all of this. And let's remember, the Court of Appeals found seven areas of ineffectiveness. And we didn't even get to the DNA argument, which the Court of Appeals said torpedoed that entire defense by not making that issue, or the fact that Mr. Clark didn't object to a stipulation that the statement was voluntary that had been made pre-trial. And our point would be on that is Clark, when asked about those issues, not objecting to the DNA misstatement, not objecting to the stipulation, he said, what? That was error. I made a mistake. There's no strategy there. With that, my time has elapsed, obviously, and I would conclude unless there's other questions.
Any other questions? Okay, thank you. Mr. Auslager, you reserve 3 minutes.
Thank you, Your Honor. Well, first, I will yet again acknowledge, yes, I did make a mistake in writing the brief in the assumption that the district court, or I said the district court was in a better position to assess Mr. Alsalaami's English skills. I acknowledge that the first argument, yes, I made a mistake. Basically, I made an assumption, and that is, it's one line in the brief, and that's all I can say about that. On the argument that the strategy was stupid, it was not stupid, because what was going through their minds here is that if they're trying to show that he was tricked, and if they were worried that if they used an interpreter, and yet the jury was aware that Mr. Alsalaami had been employed as an interpreter for several years, that essentially he would lose credibility. He was trying to create the image that he's this poor foreign man who didn't understand what was going on, and because he didn't speak the language, and yet he did speak the language, and they were worried about losing credibility. That's a valid point. And as I said at the beginning, it doesn't have to necessarily be correct. It doesn't have to be what the best attorney would do. It just has to be reasonable. And that was a reasonable point, especially considering the jurisdiction they're in, where there likely are veterans of the Iraq War. The policeman was a veteran of the Iraq War who had been in Iraq, worked with Iraqis, worked with interpreters. Their concern that they could have lost credibility with the jury was valid, and that is a valid strategy. They investigated, they made a valid strategic decision. The fact that other attorneys would ask you,
so what you're saying is that there is a reasonable attorney out there, or there is an attorney out there that would believe it was reasonable when weighing whether my client's not going to understand what's going on at trial versus the jury might think that he's trying to dumb down, that all attorneys out there would say, oh, definitely just don't get an interpreter. It's okay that he won't understand what's going on at trial.
Well, I would say there's a flaw in your hypothetical in that you said weighing against the possibility that my client won't understand what's going on at trial. They assessed that he did understand, that he did speak enough, and he was strong enough in English that he would understand what was going on at trial. And I would say that a couple of other things. One, he never gave any indication during the trial that he didn't understand what was going on. He never, there was never a point where they had to call time out and explain things to him, because he never said he didn't know what was going on. He didn't understand what was going on. They talked to him daily about it. He never gave any indication that he didn't understand what was going on. The idea that counsel talking to him and dumbing things down somehow indicates that he didn't understand. You could say that about any client who doesn't understand, what's going on in a legal proceeding. I mean, that doesn't mean anything really. And as far as whether or not he knew he had the right to have an interpreter, yet Mr. Clark didn't tell him, there's a statute that says you can have an interpreter, but they told him, you can have an interpreter. We can get an interpreter for you if you want one. So he understood he could have an interpreter. With counsel, they jointly decided that he did not need one, and they thought it would be unnecessary. While I have more to say, I realize my time is out, so I will conclude there and simply ask the court to reconsider its prior ruling, and rather than and essentially, I think the dissent had it right, and I would ask the court to follow that reasoning.
Any other questions of counsel?
Do you mind briefly addressing Mr. Nay's point that as to his comprehension at trial, the Court of Appeals found that the district court's findings were not supported by substantial competent evidence?
Well, I think the Court of Appeals reweighed the evidence. I mean, there's plenty of substantial competent evidence to support the district court's finding. I mean, the district court was very careful in citing to the record all of the points of evidence, all of the facts that supported its finding that he understood English. And I think it really was the Court of Appeals reweighed the evidence. The district court said, look, I recognize there's conflicting evidence. I resolve this evidence in favor of the state. Then the Court of Appeals got it and said, no, we see there's other evidence, and essentially reweigh. If that's not reweighing the evidence, I don't know what reweighing the evidence is. Did I adequately answer your question? Okay.
Any other questions? Okay. Thank you, counsel. The court will take this appeal under advisement. Court is now in recess until 11 a.m.
Thank you.